So let me just tell you that I heard and I watched, and the one thing I'll say is they kept saying about what I said right after. This was an insurrection, if it was an insurrection, which there were no guns, there were no anything.
Question. The Colorado Supreme Court concluded that the violent attempts of the petitioner's supporters in this case to halt the count on January 6th qualified as an insurrection. You say it did not involve an organized attempt to overthrow the government. So
that's one of many reasons. But for an insurrection, there needs to be an organized, concerted effort to overthrow the government of the United States through violence. And this
so the point is that a chaotic effort to overthrow the government is not an insurrection?
Oh, that's gotta hurt!
While Trump unveiled his latest defense to try and excuse himself from inciting an insurrection.
It was an insurrection caused by Nancy Pelosi.
Now are you sure you mean Nancy and not Nikki, Donald?
By the way, they never report the crowd on January 6th. You know, Nikki Haley, you know, did you know they destroyed all of the information, all of the evidence, everything? Deleted and destroyed all of it, because of lots of things. Like Nikki Haley is in charge of security. We offered her 10,000 people, soldiers, National Guard, so whatever they want. They turned it down. They don't want to talk about that.
Oral arguments were heard today in Trump's appeal of a Colorado court's decision to remove him from the election ballot for inciting an insurrection. Justices Sotomayor and Ketanji Brown Jackson were certainly the most surgical in their attempts to dismantle the foundation of Trump's argument, with Sotomayor stating that his lawyers are, quote, relying on a non-precedential case by a justice who later takes back what he said.
You admitted that the concept of self-executing does generally permit states to provide a cause of action for breaches of a constitutional provision.
Correct.
In fact, they do it frequently for takings clauses. There's no debate that Colorado has provided that cause of action. You want to go a step further and say that this, like the treaty clause, requires implementing legislation to permit the state to disqualify an insurrectionist.
That's correct. So
under Section 3.
That's right.
So history proves a lot to me and to my colleagues generally. But there's a whole lot of examples of states relying on Section 3 to disqualify insurrectionists for state offices. And you're basically telling us that you want us to go 2 steps further. You want to, maybe 3. You want us to say that self-execution doesn't mean what it generally means. You want us now to say it means that Congress must permit states or require states to stop insurrectionists from taking state office. And so this is a complete preemption in a way that's very rare, isn't it?
Well, that's the only thing I would disagree.
It's rare under the 14th Amendment.
Oh, of course it's rare. This is.
And as to Justice Kavanaugh, he seemed to be all about federal rights and not states' rights during the oral argument.
He had the opportunity to call witnesses remotely. He didn't use all of his time at trial. There was ample process here, and this is how ballot access determinations in election cases are decided all the time.
Okay. Second question. Some of the rhetoric of your position, I don't think it is your position, but some of the rhetoric of your position seems to suggest unless the states can do this, no one can prevent insurrectionists from holding federal office. But obviously Congress has enacted statutes, including one still in effect, Section 2383 of Title 18 prohibits insurrection. It's a federal criminal statute. And if you're convicted of that, it says shall be disqualified from holding any office. And so there is a federal statute on the books, but President Trump has not been charged with that. So
it was interesting hearing him and his fellow conservatives questioning the lawyers whether states could be trusted with such discretion. It's ironic because not that long ago in Dobbs, Justice Kavanaugh thought states the model of discretion when it came to abortion laws. He was not only willing, but thought it necessary to put it into the hands of the states, something as important as the privacy right of a woman and her right over her own medical health. States not only could be trusted, they must be trusted with this right. according to him. Yet here, states couldn't be trusted at all with issues of election laws relating to the presidency. Hypocrisy at its best. Either states aren't actually that trustworthy, or the rights of a woman were less than the rights of somebody to become president. Just saying.
Question. The Colorado Supreme Court concluded that the violent attempts of the petitioner's supporters in this case to halt the count on January 6th qualified as an insurrection as defined by Section 3. And I read your opening brief to accept that those events counted as an insurrection, but then your reply seemed to suggest that they were not. So what is your position as to that?
We never accepted or conceded in our opening brief that this was an insurrection. What we said in our opening brief was President Trump did not engage in any act that can plausibly be characterized as insurrection.
All right, so why would this not be an what is your argument that it's not? Your reply brief says that it wasn't because I think you say it did not involve an organized attempt to overthrow the government. So
that's one of many reasons. But for an insurrection, there needs to be an organized, concerted effort to overthrow the government of the United States through violence. And this
so your point is that a chaotic effort to overthrow the government is not an insurrection?
No, we didn't.
Justice Kavanaugh was also concerned with voter disenfranchisement. While it's true that people disagree whether or not allowing Trump on the ballot is a proper way to protect our democracy from Trump, Colorado's attorney gave a fantastic answer to Kavanaugh's question. He answered that Trump had already tried to disenfranchise 80 million Biden voters, and he shouldn't be given another chance.
We are here because for the first time since the War of 1812, our nation's capital came under violent assault. For the first time in history, the attack was incited by a sitting president of the United States to disrupt the peaceful transfer of presidential power. By engaging in insurrection against the Constitution, President Trump disqualified himself from public office. As we heard earlier, President Trump's main argument is that this court should create a special exemption to Section 3 that would apply to him and to him alone. He says Section 3 disqualifies all oath-breaking insurrectionists except a former president who never before held other state or federal office. There is no possible rationale for such an exemption, and the court should reject the claim that the framers made an extraordinary mistake. Section 3 uses deliberately broad language to cover all positions of federal power requiring an oath to the Constitution. My friend relies on a claimed difference between an office under and an officer of the United States, but this case does not come down to mere prepositions. The two phrases are two sides of the same coin, referring to any federal office or to anyone who holds one. President Trump's other arguments for reversal ignore the constitutional role of the states in running presidential elections. Under Article 2 and the 10th Amendment, states have the power to ensure that their citizens' electoral votes are not wasted on a candidate who is constitutionally barred from holding office. States are allowed to safeguard their ballots by excluding those who are underage, foreign-born, running for a third presidential term, or, as here, those who have engaged in insurrection against the Constitution in violation of their oath.
Because liberals tend to always believe, for good cause, that federal power is necessary to protect people's rights from rogue states, the flip of the states' right issue by the conservatives in this case means this court will very likely rule against Colorado, which leaves us in this scary position of there being no current mechanism by which a president or vice president who commits an insurrection can be prevented from doing it again. It seems that according to the Supreme Court, what would be required is congressional action. Considering the state of affairs in Congress, where the GOP can barely elect its own speaker, never mind the GOP being able to gather or count its votes for their own grandstanding witch hunts.
Yeah, Manu, take a look at this. 215, 215. That's the totals right now with zero time left remaining. What's going on?
I will tell you exactly what's going on, Wolf. We had expected Democrat Al Green to not appear for this vote, which is why we thought they can afford 3 Republican defections. It appears that Al Green has showed up and is voting against this, which has changed the math. Now a new speaker struggling to get his agenda through.
I had many people reach out to me via text message and say, what the hell are you guys doing up there?
When you have the majority, there is an expectation that you will be able to govern, and we've just struggled with that over and over again.
With the slimmest of majorities, the House GOP has struggled to simply keep the lights on for the government.
The idea that the parties can ever come together to enact actual legislation protecting our country is laughable. It's also really scary. We'll see when we get the actual written opinion if the Supreme Court addresses that and tries to protect us at all from that. Unlikely the Supreme Court will rule in Colorado's favor. Most likely, Trump will remain on the ballot in all 50 states.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.